Flaster Greenberg presents New Jersey's Site Remediation Reform Act, a practical approach. This program was recorded November 18th, 2009 at Flaster Greenberg's Conference Center in Cherry Hill, New Jersey. In this segment, the question and answer session with all of the presenters from our panel, moderated by Frank Riesenberger of Flaster Greenberg.
The only ridiculous question that you can ask is the one that you haven't asked. Okay, so fire away.
I guess my first question would be, how will existing ACO agreements with DEP be affected by the new rule? I know they're court-ordered documents, and I don't think they can be superseded by regulation, but even though I think that's what this new rule says, how will that affect ACOs?
An existing ACO will still remain in place, but as the phase-in continues, you will, for example, you'll have to deal with the mandatory timeframes. Those will replace what other timeframes may be in your ACO. Now, the chances are, if you have an ACO that's been around for a period of time, you've gotten past the preliminary mandatory timeframes of like the preliminary assessment and site investigation. So, if you have a little more specific to your question, maybe I could be more responsive on that.
Well, I guess it's really, can the new regulation, the mandatory timeframes and the new regulation supersede, say, more generic or more general timeframes in ACO agreements?
Well, if you ask the DEP, the answer is yes. That's a question that might wind up getting litigated. But I think you should proceed with the assumption that you need to comply with the mandatory timeframes now that they're in, that when they will be in place. I mean, they're not yet in place.
I saw on your website you did something on Consumer Fraud Act last week or in the last couple of weeks, and I was curious about the potential impact to LSRPs from the Consumer Fraud Act provisions of not following regulations and those kind of things.
That's a very good question.
Thank you.
We put on a lot of continuing legal education here, and that was one of them. What we will do is this. I would like to get your name and information, and we will get back to you on that. That's a very interesting question, and we will definitely explore that with some people who are more expert in the consumer fraud area, but I appreciate that. I imagine that your question presupposes something that the LSRP has done that would constitute some outrageous statement or some act of fraud, so we're going to assume that.
Well, actually, no. I would, from reading through the paper that you had on your website, there was a comment that was made that provisions of, I guess, the current version of the act in New Jersey doesn't require that you prove, an intent to deceive, and I think that there's a lot of potential here to miss minor, in my opinion, minor regulatory requirements that could be maybe even viewed as frivolous, but they could be looked at as you missed it, even though it may not have in the overall outcome, it may not make a difference in the decision. You still miss certain regulations and requirements at some small level, and I don't know, how that would impact, the LSRP's liability.
Here's my take on it, and I think this may be the basis for Frank's wanting to get back to you. Neither of us are consumer fraud experts. I think it might have been Jim Kozachek's article you're referring to. He does a lot of work in this area. The threshold legal question that I frankly do not know the answer to is, does the Consumer Fraud Act in New Jersey encompass the provision of services? I know it deals with sales transactions, but I'm not sure whether it covers people who render services. I somehow seem to recall reading a case in the distant past that said it does not. So if that's the case, then it's not applicable to LSRPs. So that's really the threshold question that we need to give you an answer on.
Hi, I used to be, for many years, an LSP in Massachusetts, and that program was fundamentally different.
You notice he said he used to be.
Yes.
There may be some questions that we may want to ask of you.
Yeah. And I'm leaning toward not being an LSRP in New Jersey. And I wondered whether you would agree with me that I think when the professional liability folks understand the full implications of this, I think that professional liability insurance is going to rival that of an OB/GYN. I think it's going to skyrocket over what it is today.
Your thoughts are very reasonable on that issue. I'm aware that on November 12th past, there was a session with the association on that issue, and there were some updates. I know that Pat attended. Pat, would you care to comment on that?
There were some discussions by some of the insurance industry who was at the conference, and they brought up that they feel that the existing professional liability does protect LSRPs. With that being said, they're looking at new products as well. And they're looking for other coverage packages, something that Mitch talked about that protects the buyers for sites where there are RAOs that are issued, that the buyer can get protection there, as opposed to just going back after the LSRP, that there are other provisions in there that would eliminate that. But there is a lot of risk. It was discussed in great detail there, but they feel that there is insurance coverage out there and that there will be additional coverage coming in. But I think, as you mentioned, even insurance carriers have indicated, and the coverage brokers, that they expect a lot of action associated with this over the next year or so. And I think they're waiting to see what it all means and really just what happens. And they're concerned more, too, than just what the DEP is doing, but, again, environmental groups and just individual citizens that now have the opportunity in the state of New Jersey, and I don't think it's that way in Massachusetts, I'm not sure, but in New Jersey have the right to challenge these things is the biggest concern that they have moving forward.
I just wanted to mention, in response or in partial response to that question, that the apparent response or the zeitgeist, the spirit of the times that I've been gathering from people who have applied for LSRPs and have received interim status or are waiting to receive interim status is that they are going to stand on the sidelines for the time being and watch and wait and see what happens. I think that is the tendency. Others are jumping in, but that is the tendency. Not to put you on the spot at all, but you want to share with us, and you don't have to, why you left that Massachusetts program.
Sure. I was in it for a number of years because I had a number of clients up in Massachusetts, but I live in New Jersey, and the continuing education requirements became fairly onerous. We also developed an office up in Massachusetts where we had local LSPs, so there wasn't a necessity of me continuing to keep my license up. But that program, worked, I would say, fairly well. There was the, potential of getting audited, but there weren't all these onerous requirements for reporting, and it's a much better run program. And I think this is going to be, as we've been talking about, pretty disastrous.
Not only do some of your considerations as environmental professionals will involve issues of coverage, potential risks, but one of the issues I know that you're all wrestling with is how do you structure your organization, put in Chinese walls or somehow provide some guarantees that the folks who are the non-LSRPs are going to be doing their due diligence in a way that does not require the reporting of deviations or the reporting of discharges, and be kept apart from those that are going to be required to report based upon the fact that they have an LSRP hat. You can't take the hat off. The hat's on. And that's something that I know that your various companies here are dealing with, whether you separate out a separate unit, whether you form a formal policy protocol which will show what your Chinese wall is and how you're doing it. That's something that we'll see how it shakes out. Yes, in the back, please.
Isn't this program just allowing DEP to have you hire a DEP agent to do the work that they would do, and then you're paying someone So then you have to pay someone else to be the one to represent you?
Yes. That's well said.
It just seems, pretty transparent that they're just putting the work over on someone else and making the client pay for it.
Before I give this off to Marty, I just wanted to comment. That's why I was making my own subjective comment on what the DEP calls its big jump, and I'm calling it the big dump, because it is a transfer of responsibilities to someone who's going to be paid to do what had been their work and their charge. And the reason why that's happening is because they're just overwhelmed and unable to do it. And there is a lot of political pressure now to try to make this work. But you said it well. Marty?
Yeah, I asked Frank to make one comment, and your question is a great segue to this comment. The one thing we haven't talked about in this room is what happened a couple of Tuesdays ago, and that was the election. We are not going to have Governor Corzine anymore. And who knows what Governor Christie will be doing. You have to think that a transfer of responsibility away from the DEP with a reduction in force of the number of DEP employees and moving things into the private sector are very consistent with Christie's underlying philosophy, of cost control, reduction of state government, moving to the private sector. So my guess is he's pretty darn happy about this and will continue with it. But the problem is you were right in the middle of the implementation phase. And one person who everybody that you talk to agrees has been absolutely essential and instrumental in doing this is Assistant Commissioner Irene Krupp. And many of you have met Irene, and Irene is a real good person. And she has put an incredible amount of time and effort into this, gotten her staff together, and she's pulled it off, but there's still a lot more to be done. And I, for one, am skeptical about what may happen. Will Governor Christie retain Irene? I don't know. If she's not there, will there be somebody who will have the guts and the gumption and the ability to step up to the plate and do it? I don't know. So a lot of this could get bogged down in politics and just administrative inertia.
Let me just take off on that and again stress this slide, which is up now. The only ridiculous question is the one you don't ask. Eileen Kropp has been readily available. She's been fantastic. The DEP is going through a process now of trying to educate everybody about what is going on in this new world, in this paradigm, in this 500-year delta. And what we've included in your materials are some of the key contact people with the DEP. If you have a question, call, ask. Don't assume. You might be surprised with the answer. You may be disappointed with the answer. And by the way, the answer may change. It may change in 2 weeks. It may change in 3 weeks. So we are really looking at a tough time right now, as Marty has indicated. I just wanted to also mention that there is, and there has been reference to, the LSRP Association. This is a very active body. It's very real. They are doing a lot of work. And whether you are an LSRP or not, you can become a member of the association and find out as much as possible what's going on. Look at their website. It costs $150 to be an associate member. I would suggest that you do that and be aware of what's going on. Also, the NJDEP has a website. If you have not signed in yet, please sign in. There's a sign-in list on the website because you will be getting updates daily. Yesterday, a guidance document came out, and a draft of a guidance document. There's going to be some changes in the vapor intrusion module. So you will be right on the cutting edge of what is going on and what is being made public. I just wanted to mention that while we were taking some questions and answers, Janet Levine stepped in. Janet, you want to just say hi? Janet is our director of marketing, did a terrific job in putting this together, as did Krista Egan. I don't know if Krista's here, but she did a great job. And, we again encourage you to ask whatever questions you have on your mind. And before leaving, we would very much appreciate getting your name and address, because we want to answer your question. And we very much appreciate you're taking the time. It'll take a little time to fill out the form, because you can help us in trying to determine what we need to do to communicate this in even a better fashion than we have had today. So, any other questions? Krista, hey, there you are. Thanks again. Yes.
The NJDP is sending out letters unassigning cases and telling you to go get an LSRP for cases that may be around since the early or late 80s. And when an LSRP picks up a project for one of those, what do you think their responsibility is to dig all the way back from the beginning of the case? Many of these were not started with a comprehensive preliminary assessment. What were done either through a due diligence or some other type of investigation that found a problem on site, not necessarily identified the actual source and time period.
If you look at Code of Ethics, Section 16I, if a licensed site remediation professional learns of an action or decision by a client that results in a deviation from the remedial action work plan or other report concerning the remediation developed by the licensed site remediation professional shall promptly notify the client and the department. G is a licensed site professional who has taken over the responsibility for the remediation of a contaminated site from another licensed site remediation professional shall correct all deficiencies. So your question then is, you took it over from somebody who's not a licensed site professional, and to what extent do you fall under the obligation to correct everything that has been taking place in that case? And that's a good question. I don't know how the DEP is going to come down on that. Has anybody else here heard how the DEP is going to come down on that? I would guess that they would require you to do that. That, to me, is something that you put yourself in the position of the state. Ultimately, if the state had its time to do that, it would. And I feel that that's probably what's going to happen.
Frank and I were both at the same meeting last Monday, and I asked that very question to Irene Kropp, and she indicated, yes, we expect you to go back and look at everything, and if there's something wrong, you're the one that's going to be issuing the RAO. Are you going to be comfortable issuing an RAO if you haven't looked at everything? She kind of left it at that. Is that
absolutely correct? What you have to do when you go into this new world here, this paradigm, is use some concepts if you don't know and try to figure out what the likely response of the DEP would be. And the likely response of the DEP has been, oh, well, yeah, I mean, the LSRP is supposed to do the work and is supposed to be comfortable with the results, the RAO, supposed to know everything about the site. And if in looking over the documents there's something that wasn't done correctly, how can you then come to the point of the RAO? You're not going to be able to do that in line with the requirements of the RAO. So, it's important to conceptualize all of this first, because it is a paradigm change. You have to kind of conceptualize what they're trying to do here. And that's the latest that we have on the position of the DEP on that issue. Good question.
Just a question, I guess, maybe at one of these meetings, I guess more recently. Have they discussed any modifications to the rule for larger sites where mandatory timeframes just cannot be met and it's impractical for them to be met? Has there been anything about that that's been discussed lately?
The DEP will probably tell you that that's already been part of their considerations for extensions, and that they will be granting extensions. They want this to work, and they want to make sure that they're not going to be in a position of asking something that's impossible.
Yeah, I totally agree with Frank. Mark Peterson is now in charge of ISRA, and I had some specific discussions with him about large ISRA projects that have many AOCs, maybe still some operating facilities that you just can't get in and get your SI done in a year, or you might not get your remediation done in 5 years. He agrees the DEP understands that. You need to go into them on a case-by-case basis, have valid reasons, and in many cases there are valid reasons, and they're going to give you some leeway.
I'm going to again direct your attention to the 6 items that are in one of the PowerPoints that Donna pointed to, and that is, what the DEP will consider if you are in a discretionary mode of seeking to get an extension of the mandatory timelines. And again, those 6 are very important, and those 6 things become part of your planning. If you know you're going to have a mandatory timeline issue, start planning on addressing some of those items because they can be addressed. And when you address those items, you'll be in a much better position to obtain your extension.
There are statutory deadlines, and there's also DEP deadlines. The DEP can extend their own deadlines, regulatory deadlines. Those statutory deadlines, which say that you have to have had the site studied within 10 years and then remediated within 5 year. There's no basis for the DEP extending that particular deadline, unless somebody's going to tell me something that I don't know. So understand that, yes, most deadlines can be extended. Those statutory deadlines cannot be extended.
Thanks, Mitch. Anybody else have some questions? I'm sure there's something rolling around your mind that you want to ask us. Fire away. Yes.
Yeah, Marty Judge touched on this, but have we heard from lenders, and are they going to be so anxious to approve funding for property transfers based on the REOs from an LSRP?
Your question is a very good question, and that assumes that they're getting to a point where they can lend in the first place. But let's look a year out, and we'll see. Marty?
One comment I'm going to make is the next time we do this, we're going to get a few more microphones. The story I've been hearing is that most of the larger banks and lenders, they're all aware of the program, and their internal staff and their outside counsel are reviewing, the situation, and they're aware of the change. They understand what's going to be happening, but I don't know that there's any set policy right now. As far as the banks are concerned, about how they're going to be treating this. I think as a practical matter, they may not like it, but they're going to have to live with it because it's the law. What I would guess is going to happen is that there will be more disclosure and more requirements in the lending documents. You may find in situations that banks that formerly were willing to lend just on the collateral may be more strict and requiring personal guarantees, corporate guarantees, and things of that sort that you might have been able to talk them out of in the past. So I don't think it's going to cause an end to the lending market. I think the economy's done a far greater job of messing that up than this. But I think it will be there'll be a period of time when I think lenders are cautious, and you may see more onerous requirements that borrowers will have to deal with. Possibly also actual requirements to buy insurance, just to back up what the LSRP has agreed to do.
Let me just take a little different take on trying to answer that question. Once again, assuming that banks are lending. My experience with many local or regional banks in the days when the 1994 amendments to ISRA occurred and the whole concept of an innocent purchaser doing due diligence emerged and became more and more an issue with banks, is that there was a long timeline before the banks got up to speed. They now have loan underwriters who are well versed in what is required now to evaluate a site. I believe it'll take them a little time as well to be brought up to speed with these new requirements. And when they are, yeah, I agree with Marty that there's probably going to be some insurance concerns, assuming that becomes available at a reasonable cost that'll go beyond the 3-year look-back period. Yep. Anybody else?
Will there be like 2 different sets of standards implemented with these programs for brownfields versus newly discovered sites from someone trying to do their due diligence? Let's say you do a public-private project with a municipality and it's been disclosed and it's on the radar screen, everyone can look at it, as being there, whereas if you discover something from a property where previous development has never been discovered?
Well, you're going to have to continue to do your due diligence in terms of property development. And our recommendation has been that you do it with a non-LSRP because of the reason that you mentioned. You may want to know what you're dealing with first before it gets...
Okay, but I guess the point I'm trying to get to is when you're dealing with a DEP and you're in an urban area and it's, urban enterprise zone or an area that's in a redevelopment zone, you seem to have a different take on the implementation of the rules and the applicability of statutes and codes and everything as compared to being out where, they don't want to see any development and there's a small site that used to be a gas station in the 50s and now you want to redevelop that site and it's not on their radar screen. Could there be 2 separate applications of rules and implementations of what will be required? Does anyone have a comment on that?
Well, Frank, are you thinking about the different tiers? I mean, if you're in a brownfields redevelopment zone, you're going to have a case manager, probably somebody who's currently in brownfield, so they're going to maintain, Mitch and I have a site together like that, they're going to maintain that brownfield zone, they're going to be the case manager for everyone. You'll still have to hire an LSRP by May of 2012, but you'll still have a case manager. But, I'll defer to Frank on this. You're still following all the same technical requirements. You're still meeting the same mandatory timeframes, the regulatory timeframes, same types of submittals, same forms. You're just going through case management, not through the direct LSRP program. Yeah.
Eventually, something like that sounds like let's make a deal with the DEP, which is what I'm used to doing. When you want to move forward and you've come to an impasse and they want the project, political inertia takes over and somehow you can work things out through a deed notice or through some sort of attenuation analysis, right?
Yeah, I think that'll still continue, but it will involve now the LSRP trying to get variances or whatever from the DEP.
And the responsibility of that will be on the case manager or on the professional?
Well, after 2012, it'll be on the LSRP professional, but he will then deal with the DEP.
Right. You'll still have case management if you're in a designated. If you're in a designated brownfield zone, what we're hearing is that you will never be in that LSRP world where you just have an LSRP submitting things. You're still always going to have a DEP case manager who you should be able to negotiate reasonable things with. So it's still going to look a lot like how you deal with the DEP now, except there'll also be an LSRP required to be your consultant, if you will, after May 2012. They still have to sign off, but the DEP case manager is going to read it and still approve it, unlike the LSRP process where you may be screened, you may go to a higher level of audit. Everything will get read in Tier 2, is my understanding.
I just wanted to mention as well that the forms that are going to be coming out, there's only 5 of them now, are going to be the required forms whether you are going to be going under the old NFA or the new paradigm under SARA. So get used to the forms because they will certainly be utilized no matter what. Also, the NJDEP is allowing you for the next 2 years to use paper as well as electronics. By 2012, paper's gone. That's going to be a big change. So you better get used to using electronics now during this phase-in period. Those are just two other items that I wanted to mention.
Well, after what you've just said, and let's say there's more discovery of unknown contamination after the project's been approved and development occurs, will the liability fall back strictly on the professional, or will it be shared by the department since they're overseeing it with an MOA?
The king is king. I don't see the department acting in any way that it's going to be responsible for anything. It just wants to, move out. It wants to move out of the territory. And there's a new sheriff in town, and there's going to be all kinds of responsibilities, possibly in that scenario that will involve the private sector.
Let me ask a question to Frank. If you're in Tier 2, brownfields redevelopment, are NJDEP still issuing NFAs? I don't know that answer.
I don't know that either.
We'll find out.
Thank you.
We'll get back to you.
In this due diligence scenario where you have a non-LSRP, what have you contemplated or thought about the responsible party's responsibility to report findings?
Depends. Mitchell, you want to take care of that? Because it depends on the discharge, what's causing the discharge, and whether you've got to report to the attorney who's got the possibility of keeping it confidential.
The Spill Act still guides that. Under the Spill Act, if you're in any way responsible for a spill, you have to notify the state. If it's a discharge from a underground storage tank covered by the Underground Storage Tank Act, you have to notify the state even if you are not a responsible party. Those still carry over. The rules on that haven't been altered. So you just go by the pre-existing notice rules.
But let me just say, this specifies conditions that are reportable by an LSRP, and I believe it may also carry those specific conditions to the responsible party as well. And that's, I mean, may alter the Spill Act in the sense that it's very specific about what conditions are reportable, and the focus has been on the LSRP's requirement to report and why you wouldn't want one for due diligence. My question is, okay, so if you don't have one, do you still have to deal with these specific reporting conditions when you're an RP?
The understanding I have is that these obligations relate to the LSRP, and they don't relate to the private individual. Remember that the LSRP is, as we said before, the surrogate for the state. So the LSRP has to notify, even though it goes beyond the obligations of the Spill Act, because he has that special status as the surrogate of the state. The individual responsible party or owner, its obligations, I believe, are still the same as that were in the Spill Act.
After the seminar, some of the questions that were posed needed further inquiry, and the purpose of this segment is to advise the results of some additional work that we've done in order to answer those questions. One of the questions asked whether an LSRP is subject to liability under the Consumer Fraud Act. Neither the Site Remediation Reform Act, known as SARA, nor the Consumer Fraud Act addresses this question directly. Therefore, absent some future statutory amendment that might make the Consumer Fraud Act applicable to LSRPs, it will be up to the courts to resolve this issue. As an example of a legislative act that did occur, in 1976, the Consumer Fraud Act was specifically amended to make real estate brokers and salespersons liable if they committed certain prohibited acts. So absent such an event occurring where the legislature takes action concerning the LSRPs, it will be up to the courts to resolve this issue. Now, based on existing case law, the courts in New Jersey have generally recognized what is known as the, quote, learned professionals, end quote, and, quote, licensed semi-professionals, end quote, exemption from liability under the Consumer Fraud Act. The, quote, learned professionals, end quote, are, as an example, doctors, lawyers, accountants, engineers, and the, quote, licensed semi-professionals, end quote, are, for an example, insurance brokers and agents, licensed real estate appraisers, and security brokers, for example. The key factor supporting the exemption is whether the professional, whether it be a, quote, learned professional, end quote, or a, quote, licensed semi-professional, end quote, whether that professional is engaged in some activity that is regulated under a scheme of professional or occupational licensure. Should that be the case, then the courts have usually held that such actions are outside the scope of Consumer Fraud Act jurisdiction. As an example, if a lawyer, accountant, or architect sold real estate, that'd be something different. And it wouldn't be within the areas that were exempt from the Consumer Fraud Act. If a lawyer, architect, or accountant would sell real estate, then the courts have occasionally held that the Consumer Fraud Act would be applicable even to learned professionals. However, if the learned professionals stay within their area of learnedness, if I can use that word, then they will continue to be exempt from the Consumer Fraud Act. In at least one recent unreported case, again, it's an unreported case of which we have become aware, environmental engineers and consultants engaged in structural foundation reinforcement work were held by the trial court in that matter to be exempt from liability under the Consumer Fraud Act because those activities were held by the court not to be the equivalent of a contracting job, but rather within the realm of the, quote, engineering, environmental, or environmental engineering, end quote, activities, which would be within the so-called, quote, learned professionals, end quote, or, quote, licensed semi-professionals, end quote, exemption to the Consumer Fraud Act. Consequently, while there has not been any determination regarding LSRPs of which we are aware of to date, it seems likely that the courts will also determine that the LSRPs are learned professionals, quote unquote, or at least, quote, licensed semi-professionals, end quote, and will extend the same Consumer Fraud Act immunity to the LSRPs as is currently allowed for other professionals. Don't know if this is going to happen for sure, but it sure looks like that is the way it is most likely to turn out. However, once again, remember that if an LSRP, like an attorney or an accountant, becomes engaged in some conduct that is arguably beyond the scope of the LSRP's licensed authority, such as selling real estate, as just one example, then the LSRP does run the risk that a court may determine that he or she is subject to liability under the Consumer Fraud Act. We also had a question concerning the impact of the Site Remediation Reform Act, SARA, on the bank underwriting of loan applications as the result of the uncertainties raised under the statute, the NJDP's implementing regulations, the LSRP auditing procedures, and the possibility that there could be remedial action outcome reopeners. Accordingly, it's likely that the banks should or would be interested in re-examining their underwriting loan applications in light of these new concerns. The response that was provided at the time of the seminar was that it took banks a long time to respond to the due diligence and preliminary assessment requirements in underwriting of loan applications in the mid to late 1990s before they reached their present level of comfort with those concepts and practices. Indeed, some have also observed that it was not until the banks and lenders were granted certain statutory immunities from so-called, quote, lender liability, end quote, in connection with loans made on contaminated properties, as was done in the New Jersey Spill Act in the 1990s, that they truly reach their present state of comfort with the mechanics and the principles in reviewing bank underwriting of loan applications. At the time of the seminar, the observation was made that it is likely that banks and other lenders, based upon past practices and how long it took to get up to speed, would again lag behind in any understanding of the complexities and changes under the Site Remediation Reform Act, at least for a period of time before the underwriters became more accustomed to the new policies and procedures under the Site Remediation Reform Act. Since that time, we've had some opportunity to discuss with bankers and those who have observed bankers in the field as to the probable validity of this observation that was made at the time of the seminar. Several other authorities have noted that whereas the insurance industry as a whole seems to be on top of the changes under SARA, and that industry is busily preparing new products to mesh with the new remediation requirements, reopeners, and other procedures under the Site Remediation Reform Act, banks and other lenders have not done much so far to gear up for changes in their lending practices and underwriting practices in this new age of the Site Remediation Reform Act. Everything that we've done in the field has confirmed the correctness of our previous observations. Thanks for coming today. Again, we'd very much appreciate it if you would fill out the form. We will pay attention to it, and we hope that we have been able to convey some of the substantive changes that are going to take place and some of the strategies that may go along with it. Thanks again for coming today.
We hope you enjoyed this program brought to you by Flaster Greenberg. For more information, call 856-661-1900 or visit flastergreenberg.com. This program was produced by Professional Podcasts in Cherry Hill, New Jersey, on the web at professionalpodcasts.com. For Flaster Greenberg, this is Steve Lubetkin. Thank you for joining us, and take good care.